Okay.
I think we're fine to get going. John, you agree?
Agreed.
Okay, well, with the permission of the chair, then I will start with the roll call. Mary Baldwin,
Here.
John Lund,
Here.
Andrew Ruda,
Here.
Judge Wendy Chang, Bridget Grammy,
Here.
Dan Grunfeld, Eric Helland,
Here.
Jim Salmon.
Here.
Thank you.
I joined late, Mimi. It's Wendy.
Oh, there you are. Okay, thank you, Wendy. All right.
Is that it for the administrative stuff, Mimi?
Yes, we can move on to public comment now. And it looks like we have one person who's indicated they'd like to give public comment. Can we begin with that? Would that be all right, Mary?
Sure.
Okay, Scott Bernstein. You'll have to,
And can you hear me now?
yes.
Okay. And how long do I have for comment?
We try to limit it to 2 minutes.
Okay, I will try to be brief. I'll try to step out of my normal self and be brief. My biggest concern is corporate practice. Well, concerns are corporate practice and subscription plans. On the corporate practice side, there are law corporations, but if a law corporation engages in some kind of misconduct or misdeed, it's on the lawyers who are its shareholders. And the lawyers who are its shareholders have a great investment in their right to practice law. If you have corporations that can be formed and dissolved at will, there is no such incentive. So if a non-lawyer corporation, a non-law corporation is selling legal services to people and is embroiled in a scandal, it still has a book of business and it can file a bankruptcy, and some new corporation with a new and different name and new and different PR can create, it can essentially take over the book and keep the train rolling. So I'm very concerned that this can turn into a vehicle for consumer fraud in the same way that auto warranty plans and product warranty plans and a whole host of other things have been. And in particular, and this is, maybe it's a bit esoteric, it's something I think about all the time, and that is the mathematics of all of this. In times of very low interest rates, income streams are king. And so if you can get people to pay $20 a month, it's $240 a year. If the capitalization rate is 1%, and things have been at historic lows for decades now, at 1%, that is a capital asset that's worth $24,000. The amounts of money, if you can hoodwink people into signing up and paying that money and just having it taken out of their debit card or their credit card once a month, they become numb to it, like the old story of a frog in a slowly heating pan of water. And again, if the corporation does something untoward, if it's bad enough, it can sell the book of business to a new corporation with a new name. I just see that the allowing non-law corporations to do this is just an obvious way to fleece the people who can least afford to be fleeced. So my suggestion would be that if we're going to allow non-lawyer practice, it should not be permitted to go on in corporate form. And the entities that are doing it should be limited to a very small size. We don't want more large-scale rip-offs of the people in our society who can least afford to be ripped off. So do I have more time? Is that my 2 minutes?
No, yes, sorry, you've already gone over.
I apologize. Thanks for letting me speak.
Thank you. Okay,
Is there anybody else, Mimi?
nope, that's all we have.
Okay, well, thanks for the public comments. And why don't we get going on our agenda for today? This is the meeting of the SAGE committee, the Structure and Governance Evaluation Enforcement. We are, in a sense, we're finishing up aspects of our first assignment and moving on to our second assignment. So, and then when I say finishing up, I don't mean that we are literally finishing, but we're getting towards the end of that first assignment. And I think first on that, with respect to the first assignment, which was the structure and governance assignment, today at today's meeting, I think we have a brief report from the Office of General Counsel. If you recall, we had asked them, and they accepted the request for legal research into certain of the alternatives that we identified and the working group voted not to approve, but to approve for further research. There were 3 different alternatives structures. So the Office of General Counsel has begun looking at those. We've set a sort of set of research issues and questions, and I don't think that they have reached anything yet, but I think Brady DeWar has a preliminary report on those, on the research results.
Yes, thank you. Let me try and share my screen here. My got 3 screens open. Are you seeing this PowerPoint, everybody?
Yes.
Okay, I'm trying to get it to show on not, well, this will be fine. So as Mary said, the State Bar's Office of General Counsel has begun to research and analyze to identify potential legal impediments or issues that might arise in implementing any of the various structures for governing the regulatory sandbox that the working group has elected to look into further, as well as whether there's any potential legal impediments to how decision-making authority might be divided between whatever body is created to oversee the regulatory sandbox in the Supreme Court. We will be providing advice on these issues at the June working group meeting, but wanted to give you an overview of the potential issues that we've identified, and those are summarized on the PowerPoint, as well as some initial results and thoughts from our analysis, and give you the opportunity today to share any thoughts or questions you might have. The questions identified for consideration that might pose issues are listed on the board, and I'll go through them real quickly. The first was whether Article 6, excuse me, Section 9 of the California Constitution provides an impediment to any particular structure for sandbox regulation. The answer that we've come to is this provision does not appear to provide any impediment to any structure. The provision in question states the State Bar of California is a public corporation. Every person admitted and licensed to practice law in this state is and shall be a member of the State Bar, except while holding office as a judge or a court of record. So the question occurred to us and some on the group, on the working group, that this language could conceivably be construed as requiring that any person or entity that engages in practice of law activities must be a member of the State Bar. However, we've found nothing in the legislative history, the limited legislative history of this provision, or the case law to suggest such a broad interpretation. Indeed, on the ground and as a matter of practice, there are many categories of people who are permitted to engage in the practice of law in California on a limited basis who are not members of the State Bar, such as those who are admitted pro hoc vici or law students who are permitted to engage in supervised practice of law. There don't appear to be any cases interpreting this language, but the Office of the Attorney General did issue a formal opinion that considered whether the limited practice of law by registered foreign legal consultants who are not members of the bar, but who are permitted by rules of court to engage in certain limited practice of law activities, whether that arrangement violates this constitutional provision. And the Attorney General's opinion made pretty quick work of finding no. They found that the plain language applies only to those who are, quote, admitted and licensed to practice law. In other words, California attorneys. not to those who are merely permitted to do certain practice of law activities like sandbox participants would be. So it appears likely that that constitutional provision just does not apply to the limited practice of law that we are considering permitting by non-lawyers in the sandbox. The second area that we're looking at is potential antitrust issues. And here, whether there are potential antitrust problems likely depends on how decision-making authority is apportioned between the governing board of the sandbox, whatever form it might take, and the Supreme Court. And Mark Schaap, who's one of our office's antitrust experts, is going to give you an overview of the principles at play in that analysis in just a moment. The third area we're looking at is the separation of powers and non-delegation doctrines. This is a thorny area, and I don't really have a lot of guidance on this at this point, other than to say that the potential separation of powers issues are likely resolved through court oversight. The issue here is that by Constitution and common law, the Supreme Court has inherent and exclusive authority over the regulation of the practice of law in the state, and so essentially the court needs to maintain some degree of control and oversight of the practice of law, and we'll flesh that out a bit more. And we are also analyzing how the non-delegation doctrine could limit the independent nonprofit option. And that's the body of case law that addresses whether, and it typically deals with whether the legislature may delegate regulating authority to non-governmental entities. And while it is allowed, there must be tight oversight. So we'll flesh that out a bit more as well. The fourth area that was identified by our Supreme Court liaisons is potential conflict of interest issues for the Supreme Court. And here we're looking at whether any particular structure or division of the decision-making authority could cause conflicts for the court. And here the thought is, assuming that the sandbox comes into operation and that various entities, including potentially large corporations, are permitted to participate in the sandbox, whether that would, under any structure or division of decision-making authority between the sandbox regulatory body and the court, whether that would create any conflict issues that would require the court to, say, recuse itself if sandbox participants were litigants before the court. The sixth and seventh areas are just looking at whether under any of the structures under consideration, the body would have the ability to contract for services from state entities, like sharing staff with borrowing staff from the state bar, or secondment or a contracting relationship with, say, the Office of the Attorney General, and also whether funding from private sources would be allowed under any of the various structures. And in our initial research on these last two, we've not found any blanket limitation that would say, no, this can't happen for a independent nonprofit or any other structure, but we're continuing to research that to nail it down. So those are sort of the broad issues we're looking at. If anybody has any questions or thoughts or potential impediments that we're not looking into yet, I'd be happy to hear those. And if not, we can move on to Mark, who will just talk a little bit about the antitrust principles we're looking at.
Brady, this is Mary. I just have an initial question on the conflicts of interest point. I thought the concern that had been raised was primarily with respect to funders of the sandbox, and whether, if those funders came before the Supreme Court, whether there'd be a conflict. I'm not sure. You described it more as participants in the sandbox coming before the court, and in that respect, I don't see how sandbox participants, to the extent the Supreme Court may have sort of ultimate oversight of the participants, I don't understand why that would be any different than, for example, the way that the Supreme Court right now has oversight over the state bar, and the state bar regularly appears before the Supreme Court, as do individual lawyers, for example, in disciplinary proceedings. So I'm just I'm not sure that we've identified that issue.
Yeah, so I agree, and that's why we're looking into it more deeply. The way that I just characterized it came from further discussions with the court staff about their concerns.
Okay. Any other questions or comments for Brady before we go to the further discussion of the antitrust issues? Okay.
Mark, are you there? Have you been promoted, Mark? Has Mark been promoted?
I'm here.
Hi, Mark.
Hello. Let's see if I can start my video.
We see you.
Okay, great. I don't see myself. I still see you, Brady, but that's fine. Hello, my name is Mark Schaap. I'm a colleague of Brady's in the Office of General Counsel, and he has asked me to speak briefly about the kind of the antitrust background and how that may inform your decision. So just generally, laws, both the federal and state antitrust laws, are designed to promote vigorous and fair competition with the aim of providing consumers with the best combination of price and quality. Taken literally, these laws would seem to prohibit any state action that restrains trade. They don't, on their face, necessarily carve out anything of the sort. However, the courts are very clear that the antitrust laws do not prohibit state action. And so the so-called state action doctrine states that state authorities are immune from antitrust liabilities for actions that are taken pursuant to a clearly expressed state policy, even if the effect of that policy is anti-competitive. Basically, that states are allowed to regulate their economies without running afoul of antitrust law specifically. So in that context, where the even where the core function of a regulatory body may be anti-competitive, as long as it's done pursuant to this clearly articulated state policy, there is not necessarily an antitrust issue. The complication comes in here when you're looking at these various structures where the state itself is not necessarily the actor that is restraining trade. The state bar is actually a very good example of this, where there are certain activities that the state bar takes that are clearly within the authority of the Supreme Court, and it's done on behalf of the Supreme Court, and other areas that are not so clearly within that. And so therefore, we have to be very careful in that context. In the second category, where a body that is not clearly part of the sovereign, that is not the court or the legislator, is the relevant actor, then in that case, there's a two-step analysis that has to take place. The first step is that the challenge, or that the restraint in question, has to be one that's clearly articulated and affirmatively expressed as state policy. And the second is that the policy has to still be actively supervised by the state. So the way, to apply this to the various forms that are under consideration, an entity that would be under the supervision of the Supreme Court could easily fit within this antitrust framework, as long as it's, as I said, as long as it's, excuse me, lost my place here. As long as that it's acting, as I said, according to an affirmatively expressed and clearly articulated policy. Similarly, an office that is part of that answers to, say, the state bar directly may be more complicated in that regard, because the question then is whether or not the Board of Trustees, comprised of a large number of attorneys and consumers of legal products as well, could effectively oversee that without running into this challenge of not actually being a state actor and having these relevant market participants in control. So I think that looking through the list, and I don't know which of these various proposals are still under serious consideration. I know you mentioned that there are 3. The memo I was reviewing had 5 possible options. The idea of an independent 501c3 is probably the most problematic. in that it would be, because it's completely independent in that regard, it would not, it would be difficult to structure that as a state actor. It would still have to somehow be under the supervision of either the court or have a very narrow, narrow amount of discretion in its enabling charter or statute or however it's put together. And that's basically it. I mean, any of these other ones, the question will become exactly how the lines of authority run. And so I think that, you know, as you move along and we can develop this further, I can give a more detailed analysis. But at the time, these are just kind of the broad issues. And I'm happy to answer any questions that anyone has.
Does anyone have any questions for Mark?
I do real quick. The one option, I don't think you talked about it, is the one where it would be an entity kind of parallel to the state bar that would directly report to the court. So is there anything about that that you think we should know from an antitrust standpoint?
Well, again, that would fall into that into this category of a non-state actor or a non-sovereign actor that would have to meet this two-prong test. And so the first prong is to have a very clearly articulated policy that is working under. And then the second part that it would have to have active state supervision. Now, active state supervision is going to be a very fact-intensive analysis, and so it will depend exactly on what you propose that would look like. For example, in the context of the state bar, the admission of attorneys is completely within the authority of the Supreme Court. The state bar merely recommends that attorneys be admitted to practice. And so that is active state supervision because it's a recommendatory process that we have. So to the extent that it would be a, you know, quote unquote sister organization to the state bar, then if it had that similar situation where the rules that it implemented were approved by the Supreme Court, and any recommendations or decisions that were made were actually recommended to the Supreme Court for approval, that would clearly fit within this antitrust framework. And again, you know, it would be a very fact-specific question to answer whether another proposal actually fits or not, but that one would be pretty easy to say that it does.
Thank you.
Any other questions for Mark? And I apologize if anyone is raising their hand, that my Zoom display for some reason is not being very cooperative today. So I feel like I'm sort of blindly operating here, so I apologize. Okay, well, if there's no more questions for Brady or Mark, we'll move on, but thanks for that preliminary report.
Thank you.
Okay, John, do you want to move us forward?
Sure. Hello, everyone. It's good to see you all. And thanks to Brady and his team, including Mark, for that work so far. What we're doing there really is tabling further specifics around, you know, the board composition and the way that the entity might be staffed and all of those sorts of questions until we have the results of this analysis. Although it sounds like it may not really narrow the options down too much, but in any event, that's where we are with the sort of those issues around board composition. But we did think we could have a conversation today around a narrow subject, and that is the question of the conflict of interests rules that would apply to this entity. And I think we can find out in the conversation, but I think the issues are probably the same regardless of whether it's under the auspices of the court or whichever structure we choose. So that's the one piece we wanted to talk about a bit today. So what ought to be the conflict of interest, and I think in our memo we said or disclosure requirements for anyone who might serve on this sandbox entity as a member of the board or otherwise.
Before we move on, I just want to remind you that we need to do the approval of the action summary. That was next on the agenda.
I'm sorry.
Before we move on to the actual agenda itself, under the discussion section, we need to approve the open action summary from the March 24th agenda.
Okay.
The meeting,
Well,
that is.
is that just a matter of roll call vote, Mimi?
Yes, it is. I
Okay.
need a motion to approve the action summary.
Great. Would somebody be willing to make that motion?
I would, but Mimi, where is that in our materials?
It was posted a day after you were sent the memos. It's on the agenda website. It's under 1E.
Okay, sorry, it's not in the set of materials that I'm working from, so sorry.
Yeah, if you're on the live agenda and click on item E, approval of open action summary, then you get to a PDF that is that summary. It's fairly basic. The most substantive piece is that Ms. Grammy and Mr. Grenfeld gave an oral report and led to a discussion on the subcommittee's recommendation for the structure and governance of a regulatory sandbox. No action was taken.
Okay, got it. And I have found it. So I'll make the motion to approve.
Okay,
Is it-
second.
Second.
Thank you, Eric.
Thank you, Eric. Okay, I'll take the roll call vote. Mary Baldwin,
Approve.
John Lund,
Approve.
Andrew Ruda.
Mimi, I
Okay,
don't
you
think,
weren't here.
yeah.
You abstain. Judge Wendy Chang,
Abstain.
Bridget Grammy,
Approve.
Dan Grenfeld, Eric Helland,
Approve.
Jim Sandman.
Approve.
Okay, thank you very much. Sorry to interrupt.
No problem. So I was going to turn to this subject of what sort of conflict of interest rules or disclosure requirements should there be for someone who is sitting on the sandbox body. And there was a link in the materials to some ideas about that provided by an entity that probably most of you know more about than I do, something called the California Fair Political Practices Commission, which appears to have been an outgrowth of concerns over the way politics worked back in the Watergate era. But I if I can, thought that I might show you on a share screen here the basic conflict of interest rules that this group is presenting for a California public official. And then maybe we can see what you all think about that. Can you see my screen?
Yes.
Yes, we can.
So again, I have not studied the full context in which these apply. I mean, this commission seems to deal with issues around campaign fairness and the like, but it does seem to deal with conflict of interest in regards to public officials. So query whether they directly apply to the type of body that we are talking about. But I think the rules are pretty basic, sensible rules. There's a list of these 5 disqualifying types of financial interests. Obviously, some sort of ownership position in an entity that I should clarify, the way I understand this works, this would have to do with the government officials' participation in a particular decision of the body. So you're sitting on the body, and before the body comes an application for sandbox authority from an entity. And the question is, does somebody on the body have an ownership interest in that entity? Is there real property interest at stake? Is there some kind of income coming to the individual from that body? Have there been gifts received? Or is there something in the personal finances that would pertain? So it seems to me that the way this works is if one of those circumstances is present, then that individual is disqualified for participating in that particular decision, assuming that the impact and so forth. This is a lot of structure around this, but the real driver is if you have a disqualifying interest, then you are not to participate in making the decision or use your position to influence the governmental decision. Obviously I'm giving this a short shrift, but I think the question is for the group is that the type of approach that makes sense for people on the future regulatory sandbox board to have that type of a constraint on their participation in something that might affect their interests? Or would you all think about approaching that in some different way? What do you think?
I have a question, Donna or anybody. Are the Board of Trustees subject to these FPPC rules? They are, right?
So the Board of Trustees is not technically subject to the, I'm trying to think of the terminology for the particular act in the government code, but we follow, the board files the same Form 700 declaration of statement of economic interests, but they're not technically subject to some of the same overriding principles, but it's something that we can import.
And I will just add that the court also follows this code of this conflict of interest code. We all have to file Form 700 every year, as well as the Judicial Council. And my understanding is it applies, every state or local agency, governmental agency has to comply with this act.
I'm going to stop the share unless somebody really needs this up any longer. So I suppose the question becomes if generally we like that concept that same approach would be taken with this board, then how do we write that into either a recommendation or a resolution around this issue? Is it a matter of writing those rules I just showed you back into a recommendation to the board? Is it simply to pass a resolution that this board be expected to comply with this set of conflict of interest rules, just like the Judicial Council and other similar bodies, and then it just tracks with whatever the rules are at any given time? Any thoughts on that, Bridget?
I think it makes a lot of sense. I don't know why we would need to reinvent the wheel. I think it just should be very clear that whoever is making these decisions does not have a profit stake interest in the outcome, right? So it doesn't really matter if they have a profit stake in the actual applicant that's applying, or maybe they could be a competitor of the applicant that's applying. I mean, they should just not have an interest in this. And if they do, that needs to be very clearly disclosed. But I can't imagine why we would want to have somebody who does have a profit stake interest in the outcome on the board.
And I certainly wouldn't worry about the drafting of it. We can easily put together language that would provide that the conflict of interest provisions of government code section, whatever, apply to the members of the governing body.
Donna, can I ask a quick follow-up question? What's the enforcement mechanism? I assume these are public, but if someone did have a conflict of interest, I mean, hopefully they would just recuse themselves and not participate in that decision, but I presume there must be some enforcement mechanism that follows up on this. I just don't know what that is.
So you are correct on many counts, Eric. These are publicly available. If we, received a Public Records Act request, we would disclose these statements of economic interest. If you have a conflict, you need to disclose that conflict, and then there are rules for recusal. So you are not making decisions on things in which you have a financial interest. And I can let Brady might be better positioned to speak to, what if someone were to challenge and say, Eric, who's on your board, failed to disclose in his statement of economic interest that he has an interest in X, which then came before the board and he failed to recuse himself. Brady, can you address how that scenario would be dealt with?
Luckily, in my 3 years here, we haven't had to deal with such a challenge. But there are potentially penalties for knowing violations of the disclosure laws, including criminal penalties, and there is, as with Begley-Keene, the possible remedy of reversing a decision of a board and having to go through it again. However, that would likely only come into play if that conflicted person's vote was dispositive.
Can I ask one more follow-up question on this? What would be the mechanism, since this is a board, for replacing? So if Eric has a conflict of interest and he steps out, does just a subset of the board? And the reason I ask this is, at least in having done a little bit of study of this in the case of judges, this can be a problem. And judges are very conservative about this. They tend to recuse themselves whenever there's even this sort of appearance. And that we're going to have a smaller board, say, than a bench of judges or something like that. That's my other question, is how we would handle that.
So if no one else is going to talk, I'm always happy to fill the void.
Thank you.
There are certainly, in most instances, what happens is you operate with a smaller panel of people, because generally, if a person is recused, they're recused from a single decision and not sort of a whole slate of decisions, right? It's not like someone papered by the entire district attorney's office, and therefore you've got no judge who can handle criminal cases in a county. Depending on what the size of the board is, presumably, the recommendation I would imagine could be made that there be essentially a conflict panel, right? That you've got, some standby alternates that you could draw from if the number of recusals gets the board below X level. That might be an option that the working group might want to consider.
And this is all pretty early, in our discussion. So, when you say, what are we, how do we deal with that? Well, we can invent and come up with ideas of how we deal with it. So, so it's certainly something to note. I'm not sure, and I don't think we have made any decisions, even preliminary ones, around the size of the board. So what we have so far are the ADL's recommendations as to the sort of constituents or the type of people that might be appointed to the board, but we really haven't gotten to the point where we've discussed size of the board or anything like that. So this might be a consideration that weighs on that issue.
Well, may I suggest this? It sounds like there's generally consensus about the FPPC and the applicable statute applying to this board, and that we maybe just put a check next to that and move on, to know that I think Donna's right, is a fairly easy thing to put into the operating documents when we get to that point. So I don't know. I'm not the parliamentarian for this process. I don't know if that's something we need to do by motion or just kind of note the consensus. And when we get to a more fulsome recommendation about the full composition issue, we can include that point. Any thoughts there as to how we pin this down?
Well, since this is just a committee and we know it's not the full working group, and the purpose of this committee meeting is to try to further pull together our thoughts as a committee for what we will consider at the June meeting of the working group. I doubt, but Mimi, you can correct me, I doubt we need to actually vote on anything. I would encourage any committee members who disagree, to speak up, because we certainly don't want to assume there's consensus or rough preliminary consensus if there isn't.
I defer to Randy on whether we need to vote on this.
So I think I've mentioned before that if you wanted to vote on it, you're certainly able. You wouldn't be making any sort of dispositive decision, because it would be just a recommendation of the subcommittee to the full working group. And the recommendation, if you just go by Robert's Rules of Order, it would have the force of a motion made and seconded. And so when it arrives at the full working group, someone can call the question on what the subcommittee is recommending.
So
You
it's-
don't have to go that route, because you can just report out to the full working group that it was the sense of the subcommittee that this ought to be the way to go, and then that could be presented in that manner without it having to be a recommendation of the subcommittee. So you have both options.
So given that this is just a small piece of a larger conversation, I think we stand with, we've got a consensus around this, and we'll put it into the paperwork when need be. I do have one other aspect of this that I want to raise and see if people have thoughts about it. You may recall at our last working group session, or maybe the one before, there was a suggestion made that people participating in either this process or potentially the sandbox should be expected to make disclosures about their sort of organization they're representing, or their interests relative to this project. I just want to raise that, because I think these rules that we're looking at do not really trigger unless there's one of these rather objective, distinct interests that somebody has that's implicated by a particular decision. But I do want to find out if someone thinks there's if you have any thoughts at all about this idea that people should at least be required to disclose what organizations they may be associated with that are circling around this issue in the industry, or anything along those lines. Anybody have any thoughts about that?
John, you mean as members of the working group?
I'm speaking more about members of, I think this would be, so that's how the issue came up, Mary. I think that's where the issue came up, but I'm wondering if there would be any interest in having that kind of a expectation about people that would sit on the governing board of the sandbox.
I think I'm having a hard time distinguishing between that and what we just talked about. Can you just rephrase it again?
Well, the fact that I had the Utah Innovation Office, which maybe reflects something about my take on the world of innovation in the legal services industry. Is that fact, well, even though it's unrelated to a particular decision that's before the sandbox, is it important for the process that be known about me, or similar things about any of you who might sit on that sandbox?
John, this is Eric. I guess I'm not sure what the limiting principle. I mean, I'm a member of the American Economics Association, right? You can draw a lot of suppositions around that. Financial interest seems to me to be well defined. I own, shares in a company that, is a subsidiary of this. I mean, I almost feel like we would be raising the burden of people to decide what to disclose. And, I don't know what, it doesn't seem like there's an obvious financial interest seems well defined. They have a Wikipedia page. I don't know. It seems very hard to think how we would limit that so that it didn't just kind of perpetually tie people up.
Yeah, I heard Andrew Arruda is a rabid soccer fan.
Guilty.
Yeah. In any event, I just wanted to raise it. I mean, I guess, does anybody disagree with Eric about that? Does anybody see there being some value? I mean, I suppose it's a message about transparency, and there's going to be generalized information about whoever is appointed to this board that's known. I mean, they're a legislator, or they're going to have a public profile in any event. But does anybody see us as wanting to recommend something more explicit around information about who's on the board being made known to people?
I do. I know I'm ex officio here, but if I can jump in the silence, I do think that if someone's going to be on the board, that their involvement in legal services ought to be disclosed. So the fact that you had the Utah Innovation Office would seem to be something that should be part of your official firm or your official board bio, as should be the fact that you are a shareholder in your law firm, for example, because that makes you at some level a competitor to some of the entities that are seeking permission to practice. And so I don't think it's in any way disqualifying because it's far enough away from anything that would make you economically self-interested. I do think that as part of transparency, it's important. And I appreciate Eric's point that that financial self-interest is a clear demarcation. And I think that's important when we're talking about recusal. But when we're talking about transparency about who the board members are, I think anything that a board member considers an important professional qualification based on whoever he or she is, and any involvement he or she has in the provision of any type of legal services would seem, provision of or regulation of legal services would seem important.
Well, that,
I just wanted to, point out, I think the discussion identifies a sort of a, I won't say blind spot, but a limited scope of the FPP CA, which is that it deals just with financial conflicts. And for the Board of Trustees for the State Bar, the State Bar Act deals with that in Business and Professions Code 6036, in addition to incorporating the standard, the financial interest standard for recusal from decisions in 6036A. It creates a recusal requirement where there are personal non-financial interests. And what it says, and again, it's hard to define, it says that a member of the Board of Trustees shall disqualify him or herself from any decision where there exists a personal non-financial interest that will prevent the trustee from applying disinterested skill and undivided loyalty to the State Bar and making the decision. And of course, that's worded as an objective standard, and any trustee could say, well, I can be impartial, but we, in helping them deal with recusal questions, always look at it from an objective standpoint. So we say, if an objective person looking at your personal interest in this would if it wouldn't pass the smell test, we'll advise people to trustees to recuse themselves. And of course, this is we don't actually have a disclosure requirement, but there is the recusal requirement based on non-financial interest.
thanks, Brady. Judge Chang, I thought your hand was up, but now it's down, I think. Did you have something? If not, I think we're on to Bridget.
Sorry, you don't have anything to change. So I guess I was just thinking of this from, I agree with Justice Tuger that it's important from a transparency standpoint, and that as a general principle, I think this regulatory board should be as transparent as possible and have bios. I guess just on my experience of, working in other occupational licensing boards, I haven't seen this as a legal requirement, or even I'm thinking of the State Bar, the Board of Trustees, just like a list of people. It doesn't say, there's no bios even. Some boards I know do have bios on their website of their board members, but I don't think the bar has that for its trustees. And I guess I'm just thinking, I like your concept. I just wonder if it would be hard to codify as we're talking about, like how do you define what needs to be posted? And could it be more of a general principle of transparency that, the board is going to aim to do this and then have bios available and try to disclose as much as possible without making it like an actual required rule, is the way I'm thinking of it.
Well, so Bridget, if the recommendation that ultimately went to the Board of Governors said something like, it's recommended in the interest of transparency that the background and qualifications and relevant experience of people serving on the board is publicly available so that, people know who's involved in the decision-making process. I mean, that's fairly general. It doesn't have like some legal consequence if you forget to say you're a soccer fan, but what is that? Does that fit with what you have in mind?
Yes, that's what I'm just thinking about, and somebody well, there's a couple things that the people would have information about if we go with what we've been talking about, which I know we haven't like set anything in stone, but we had a list of, we want to have an economist and we want to have a tech person, and, we could have, I can imagine that on the website, it would be listed, this is the tech person, on the board and here's this person's bio, or when they're appointed, usually I've seen like press releases like, oh, the board, this person's just been appointed to this board and here's their background a little bit. So that I just think it could kind of go along with the practices of what a lot of licensing boards do, along the lines as you recommended.
Mary?
I was going to say something along that, and I think it dovetails with what Bridget just said. It seems to me that what we're talking about are disclosures that are important to understand, who the board members are. And I think disclosures of this kind should absolutely be required as part of the appointment process, going back to, the fact that we are looking, at least as preliminarily, set, at least following the lines of the ADL's recommendations, we're looking to fill certain types of positions with certain types of people. And I think it's reasonable to require disclosure of, each person's involvement in the legal services industry. And that makes a lot of sense. I don't necessarily see that as part of the conflicts of interest policy, which, are the rules that we would adopt, that would be adopted to define when an individual board member needs to recuse themselves. I see those as different things, as I think Bridget does too. Important, but not necessarily part of the same thing.
Thanks, Eric.
I think Mary said most of what I was going to say, but one possibility, presumably these board members will be appointed by, it sounds like the California Supreme Court. I know we haven't actually decided that yet, but there would be an entity and they could be removed. And so I do wonder if that's the way to do this sort of disclosure, is to say, Eric did not disclose that he was a soccer fan. That's sort of relevant for this decision, whereas the conflicts of interest are one-off. You step out, for sort of this one in particular. And so I guess I wonder if the disclosure here, I'm still trying to wrestle on something or wrap my mind around something that would be a one-off conflict of interest that wouldn't make me, for example, not qualified to be on the board or something like that, right? So I wonder, if there's an example of that, I guess I'm fine putting in the conflict of interest, but it strikes me that maybe we want to say that this is disclosure to the entity that's doing the appointments, and that entity can remove you if you don't disclose something.
So let me, Mary, did you have something more? Your hand's still up.
No, sorry.
Okay. I guess maybe if I could summarize this, it sounds to me like we've got at least three sort of related but separate topics. One is the conflict of interest, to which the FPPC, structure seems to be the piece that we would want to see in place. The next is that there be some requirement for disclosure of relevant background, however we word that, pertinent experience in the application process before people are appointed. And that if there was a problem with, what was represented there, it would be up to the appointing body to address that particular problem if somebody didn't tell them they were a soccer fan. And then the third, and I think the one that was driving Justice Tucker's comment, is that there be transparency, to the public about who the people are that are on the board. And that's this idea that there'd be some, general information being made available about the background and relevant experience of those people. They're related, but I think those are kind of three different facets of this. Is that a fair summary of what we've been talking through? Would anybody modify that in some way? Because I'm thinking what I don't know, again, mechanics of moving these things forward is that we ought to get this written down somewhere, whether it's a recommendation or a resolution, whatever it is, so that we have it. I think our action reports are great, but they're pretty skinny when it comes down to going back and finding, out what the conversation was about. So that's my question here, is how to really be sure we condense this and get it down somewhere that we can go back to it and say, yeah, this is the conversation we had.
John, this is Randy.
Yeah.
I'm just wondering where we might fit Brady's reference to 6036 of the Business and Professions Code, to the extent that the broad concept of the FTPC is that a state sort of official in a regulatory environment has to be complying with a conflicts of interest code, the bar has adopted a conflict of interest of code that isn't just the FPPC, it includes 6036. And so if this is going to be possibly a parallel structure to the bar, then that sort of baseline might be relevant as well. And so the governing body ought to consider things that aren't explicit financial interests, but also the type of things mentioned in 6036, which in a way is not a far cry from what standard attorney conflicts rules would require, which are also not limited to just financial things. They include professional and personal and professional interests as well.
Thanks for that, Randy. So just to wrap this up, my thought is that I'll write up a summary that you can all look at in between now and whenever we next meet, and we'll have that at least to review and further think about. Does that work for you, Mary?
That sounds great. That sounds like the perfect way to go.
Okay.
Can I ask, before we leave the subject entirely, can I ask John how Utah's practice in these areas compare to what we've just been talking about that we might recommend?
Well, you know, to be honest, it's making me feel like we're just guys in a garage over in Utah. I mean, in other words, I just think this is a much more carefully thought through, you know, structure than what we've done. We do have postings about the information who are on the board. You know, there was a application process and appointment process utilized by the court. As to the conflict of interest piece, we don't have the equivalent of the FPPC, you know, in Utah. So I think it would be a much more general conflict of interest, maybe along the lines of what Randy's talking about for the lawyers involved. But
Well, you should know that guys in the garage are lionized in Silicon Valley, so you don't have to be modest about that.
well, yeah, but anyway,
Thank you.
thank you.
Okay, so I think that finishes our discussion of item 1 in our assignment today. Do you have anything else, John, on our structure and governance assignment piece?
Nope. Thank you,
Okay.
everyone.
All right, good. So that took up an hour. I think we thought it was going to take about 15 minutes. So excellent. Now we move on to the second piece of our agenda, which is our new assignment. And that is a risk-based approach to sandbox regulation. And so for this, we looked back at the charter of the working group and pulled out 3 of the numbered parts of the recommendations that we are being tasked to come up with. Numbers 5, 6, and 7. These are listed in the agenda. 5 is to come up with recommendations concerning record keeping, reporting, data collection, and sandbox evaluation metrics. 6 is program oversight for persons and entities accepted for participation in the sandbox, including standards of conduct, processing of client complaints, etc. And then number 7 is termination of the sandbox and rules and procedures around that. So for what we did for today is Jim Sandman took responsibility for coming up with a discussion outline for number 5. And I took responsibility for coming up with a discussion outline for number 6. So that's what we have here that were distributed. We did not yet address number 7 in case you were kind of hunting around for that. But that seems appropriate since it's termination and, we'll start from the beginning. So why don't we start with Jim's memo, which is the one we didn't identify these very well, I don't think, for you. So sorry about that. It's the one that's entitled Proposed Guidelines for Collecting and Analyzing Data to Assess the Risks of Sandbox Entities. And Jim, why don't you walk us through your outline?
Thank you, Mary. As Mary mentioned, this is dealing with charter assignment number 5, record keeping, reporting, data collection, and sandbox evaluation metrics. What I've tried to do in the outline is to lay out a logical framework through which we can go step by step to identify what the record keeping, reporting, data collection, and sandbox evaluation metrics should be. I propose that we adopt a risk-based approach. That's because the introductory language talks about protecting the public, that we ask first, what are the harms we are seeking to assess the risk of? Second, what is the standard of review for assessing the risk of harm? And third, this is kind of a catch-all, what information do we need to be able to conduct the risk assessment? Does that information vary by applicant? If so, are there categories of applicants we can identify that would allow us to manage information collection requirements efficiently? How do we balance the burden of collecting information against the value that information has? In the course of answering all these questions, we might want to try to identify some principles to guide us. For example, that the regulatory burdens we impose be commensurate with the consumer harm potentially at risk. The regulation should not stifle innovation. And second, we should aim to have record keeping, reporting, data collection, and evaluation processes that are manageable at scale. We're talking about California. We have to have something that is workable in the event, the foreseeable event, that we have a number of applicants for SANDBOX status and need to be able to operate efficiently. This needs to be operational. So if that order of proceeding is acceptable to people, I propose we start by asking the fundamental question that should guide everything else. What are the possible harms to consumers of the legal services provided by SANDBOX participants? In the outline, I identified three. My source for these three sources were the ADLS report and the office manual of the Utah Office of Legal Services Innovation. Both the ADLS report and the Utah Office Manual identify the same three potential harms. They phrase them a little bit differently with regard to the first harm, but otherwise they're pretty consistent. There could be other harms. John and Mary and I talked earlier today about the process that was gone through, I think, in the UK. That led to Utah to identify the three harms that you see here. The list in the UK was longer, but John's assessment was that that this reduced list captures in a more efficient form all of the risks that were identified in the UK study. So with that, I'd open it to questions, reactions about these three harms. Are these the right ones? Are there additional ones?
So can I suggest there might be an additional aspect to the third one, or possibly an additional one, which is that the consumer pays an unnecessary and inappropriate amount for the legal services. So it's closely related to the idea that's there already, but it's not the service itself that's unnecessary or inappropriate. It's just that you're paying $18,000 for it when you could have bought it for $2,500 or whatever.
I'd consider that a friendly amendment.
This is Mary. I guess one question I have about these, and I too, Justice Tucker, you and I were on the same wavelength with that last one. But another aspect, which I maybe captured already here, but it's what if what about the consumer who is actually harmed as a result? So, you know, in terms of legal malpractice, we think of, you know, harms as in, you know, someone actually suffering, you know, damages as a result of an attorney's conduct. Couldn't we think of a scenario where that might be a risk that could happen here? We have, so in A, it's receives inaccurate or inappropriate legal services, or an inaccurate or inappropriate legal result. Maybe that's intended to encompass the kind of the legal result that actually harms them. I guess that would be inappropriate or inaccurate. I don't really know about what accuracy means in that context.
I think, Mary, that was the intent of this. I agree with you that it may not be worded as well as it could be. I think it doesn't require a showing of actual harm. If you got bad advice at the level of malpractice, I think that would be a problem and a harm to be protected against, even if you couldn't, in a court of law, prove damages.
I had a sort of similar question. Could you elaborate on why not this isn't so much a disagreement, I'm just not sure I understand why harm isn't the standard here, but sort of, you have later in the memo about, that relative to, say, what would have happened had they not had any legal representation. But this seems a little broader, right? That you're really asking about the accuracy. And I'm just curious why the difference.
For purposes of this exercise, I just laid out what the ADLS report said and what Utah has done. That's a really good question. Should there be a no harm, no foul approach?
I think since we're talking about potential harms, it's okay to say potential harms are caused by these kinds of fouls without necessarily addressing the fact that sometimes there are no harm, no foul outcomes. And with no offense to John, I'd like to put in a statement in favor of the ADLS as opposed to the Utah formulation on the first prong, because it seems to me you can get an inaccurate or inappropriate legal result for reasons that have nothing to do with the quality of the legal work. Say the judge made a mistake.
Not that that ever happens, Justice Tucker.
Hey, I'm there to make sure it doesn't.
If I could just, this characterization of potential harms, I think it's important to understand, and maybe we have a different in mind, but that tool for us is an assessment tool. It's about looking at the proposal, and trying to contemplate what could be a problem with that particular proposal. And I do think it's easy to let that flow into, well, what if one of those harms is realized? What will be the remedy for that particular piece? But at some level, I think this is an experiment. At least it is in Utah, and I think the sandbox in California would be an experiment as well. And and so we're really trying to find out if indeed there are these sorts of harms from allowing other actors into legal services. So I don't know if that goes to the wording, but I just think in terms of the context, that's important to keep that in mind. Because and maybe it's easier to think about this in an actual application. If a person is using this tool to get a financial disclosure for a divorce case put together, and there's an error caused by the system, and they turn in a filing to the court which is incorrect or incomplete in some respect, I think we could all agree that then that's an inaccurate legal service. They didn't get what they were supposed to get. It might even be an inaccurate legal result, Justice Tucker, but it's certainly an inaccurate legal service. And And that's a problem. That's a problem, to know about and to figure out how to avoid if we're going to allow that service to continue to provide. But, and maybe this is Eric's point, what the consequence should be for the company, which gave that bad, piece of information to that consumer that then went into court and probably maybe just got a delay in their case or something that's pretty hard to quantify, is definitely a different subject and maybe not the one to tackle when we're articulating what the harms are, the potential harms.
Yeah, that's really helpful. I think I was thinking about this the wrong way. In theory, if this is a company that's producing disclosures that I can then take into divorce court, if it caused me harm, I could sue them under sort of products liability. But what we're really talking about here is how does the sandbox become aware that this is getting to be a problem and there's something wrong with the service, and how does it judge the risk of letting this service enter in the first place? That's a really good point.
Other comments on these? I have a question, John, on the second bullet. The consumer fails to exercise legal rights through ignorance. How do you know that? How do you assess that? The consumer's state of mind, particularly when you're doing this on a mass and not a case-by-case basis.
Well, I was never told when I entered this lease that this person helped me enter, that if my roommate wasn't on the lease, that they weren't going to have to, then they weren't going to have to pay the landlord. I was never told that. I didn't know that.
I got it. I didn't, that's not the way I read ignorance.
Okay.
I mean, what you're talking about is the lawyer didn't adequately disclose what the consumer needed to know.
Yeah.
Yeah.
It could be subsumed in the first bullet, in some respects, but.
Just a quick follow-up on that point, John. I felt like you were actually saying something there that was different than the first bullet as I understood it, that I could get totally accurate legal advice, but it could leave something out that was sort of critical my decision-making process about my roommate. Then you seem to say the reverse, actually, that it was actually that it would be subsumed in number one.
Well, I guess maybe we should just call them close sisters. I mean, I think you're right. It is a little different. I mean, you could give perfectly appropriate assistance to somebody writing a lease up for them, right? And it'd be appropriate legal services, but this whole piece about the roommate never got dealt with. Is that bad legal advice, or is that just you weren't ever told, so you never addressed it?
I mean, this just seemed really important to me in the sense that I could easily see products that are too narrow, right? That I have something that's totally accurate, but it doesn't disclose when it's inappropriate. You shouldn't be using this, service to write your will because your will is actually more complex. And I could see that being a situation where a company might not want to make that disclosure because it would say, don't use our service, Eric. It's not appropriate for you. You have a much more complicated estate planning problem than our website can sort of provide. So I at least as I understood this initially, I kind of liked this point because it seemed like it required you to disclose to potential customers what the limit of your service is and for whom it is not something they should be consuming.
I like that there are separate points here. I wonder, to address Jim's focus on the word ignorance, whether it would be an improvement, instead of saying ignorance or bad advice, to say bad or incomplete advice.
Right, because the ignorance could be Yeah, ignorance is sort of the wrong choice of words there. I would tend to agree with you, Justice Tucker.
It also does set some people off.
Yeah.
Who are you calling ignorant?
Right.
Yeah.
Yeah, I like the term incomplete advice, because I think partly what we're talking about, is the importance of disclosing to consumers not only what they are getting and the effect of what they are doing, but also any necessary corollary or follow-on things that they might want to do or have to do, and that I think that's better accomplished by the incomplete advice concept.
So if I might add, one of the things that's jumping out at me here is lawyers are permitted to provide unbundled legal services. And as I recall the rules, and Mary, you probably know them better than I, with unbundled legal services, right? You're not required to tell them everything that might be impacted by the particular issue that you're dealing with. You need to disclose, however, I think, right? We are going to deal with this very particular issue at hand. I am not, I'm not advising you one way or the other about X, Y, or Z. And so I think we just want to make sure that we're not imposing a broader requirement here than is imposed on lawyers under those unbundling rules.
Yeah, a lawyer needs to make clear basically what they're not advising the client about.
But I think for purposes of this exercise, we're trying to just identify, just to start out with, what are we worried about, right? We're just trying to say, what do we want to prevent? And then we can figure out how we would prevent that, or what kinds of things we can put into place.
Mm-hmm.
To me, I think that's why it's good that they're so broad. That I remember Andrew, I mean, it's been a while now since we went through this, but we kind of went around and around about this on ADLs, and this is what we came up with.
Yeah.
In the on-screen edit, I think we need to take out ignorance or. Thank you. Any further comments on these?
This is Randy. Just to follow on what Donna was describing, it is sort of a tricky thing when you use the term advice, because advice is essentially a legal standard of the service you're providing. I'm giving you legal advice, and the legal advice you give follows from the scope of representation. And I think it's been hinted at that some of the innovations that may come into the sandbox may be discrete as opposed to the entire legal service, might even be very small sets of sticks, commoditized legal services provided primarily through technology. And when you constrict the scope of the service, then the obligation to give advice concomitantly is limited. And so in California, we have an appellate court decision, Nichols v. Keller, that tries to distinguish between what the lawyer is responsible to advise upon when there's a limited scope, and what the lawyer has a duty essentially to inform and alert the client to. And I think that's what part Mary was describing, that if, like the Nichols case, if someone had an employment issue and the lawyer filed a workers' comp, because that's all they do, they just do workers' comp, but the client missed out on a third-party claim that another lawyer would have easily identified and would have informed the client about, and whether the client chose to get legal advice and services to pursue that claim as a separate and distinct remedy from the workers' comp remedy, it would have been on the discretion of the client. But if the client is, I'll use the word ignorant, doesn't know, because the commoditized technological legal advice delivery system does not have a way of alerting the client, informing the client that when you have a workers' comp, you might want to also get down the path of a third-party lawsuit, because those are oftentimes involved with this type of case, but not always. And the service provision you're receiving is not broadly encompassing that remedy, doesn't include that scope. And so the limited scope being provided is not going to advise you about it. It can, there should be something that alerts the consumer to things that are outside the scope of representation. You don't necessarily have to advise them if they have XYZ remedy beyond what the consumer has come to the delivery system to actually receive, but it has to somehow inform them or alert them if you want to be comparable to what the standard is for lawyers.
And if I can just make a follow-on point to that, because I think that's a really, really good point. And to John's point, I mean, since we're not really talking about remedies, we're really talking about how the sandbox would do risk assessment. It suggests if you're doing something where you're just filing workers' comp and you make that very clear in your application, the sandbox should raise that to a higher risk profile, right? Because there's more chance that you will be giving people incomplete legal advice. So it's a really good point, because it's, if it's a very narrow scope where, it's not common that there would be this overlap where your service is so narrow. But I like that way of thinking about it, because it does suggest you need to move things up the risk assessment if it's going to be something that regularly there are, say, two types of claims and this service is only dealing with one. I have no idea how common what you described is, but if it's fairly common, I would think the sandbox would want to look at that as a pretty risky entry into the market.
And this is Mary. I would say that to the extent that Randy was focusing on the word advice and suggesting that the use of that word would be somewhat narrow and would only refer to matters within the scope of the services provided, we could broaden it slightly to say bad advice or incomplete information. Because just as a term of art, there's a distinction between legal advice and legal information. Information's much broader. And I think that would address that. This might be angels dancing on the head of a pin for some of you, but for those of us who really look to that distinction that Randy pointed out, I think that would be more precise language.
So you want me to add information here?
So it'd be bad advice or incomplete information. So the advice would be the bad advice. So advice would be, part of and within the scope of what the provider is doing for the client. But information is broader than that and would encompass things like telling them, I don't represent, you may have a legal a wrongful termination claim. I don't do that. We're not advising you onto that. You need separate counsel or whatever it is. It's not just within the scope of what the provider is doing.
I do just want to add, this is where it's hard for me sometimes that we're operating on two separate tracks, because I think Randy's point about the scope is really important as far as it's hard for me to wrap my brain around how we're developing this whole mechanism for how the system is going to work when we don't know what the scope is going to be. And I mean, for me, what you just described, Randy, I mean, I don't want to go derail this conversation, but I just will say, it worries me that we are talking about limiting the scope so much, because I just feel like it overcomplicates it. And I would vote for not limiting it in that way and to try to address it through this actual risk-based model. What are we worried about? And then develop the model and the risk assessment based on what we're worried about, instead of trying to be overly prescriptive about who can and can't apply to the sandbox. So anyway, I just would like to say my opinion about that.
Let me just say, it wasn't scope of the sandbox when I was using that term. It was really scope of representation along the lines of limited scope or unbundling. So like Jim said at the outset, the principles that we're listing as harms are the first step, because that will guide, we're talking about risk-based, which would be proactive type regulation. So what data do you collect to be able to ascertain whether these harms are occurring, and what methodology do you use to collect it? And when you have that data, what are the metrics used to analyze it to determine if you're finding out what you want to find out about these harms? And so I think, I don't think the articulation of the harms limits the scope of the sandbox. If it has any limitation, it's on the data that's being collected. And at some point, I think we want to also ask the question of, aside from data on harms, should we be looking for data on benefits or improvements to access to justice? I know I asked Lucy about that when she presented to us, and that's not the direction that the Utah approach is taking. But beyond the principles of ascertaining harm, I think our final report should say something about whether we're collecting any data on improvements or benefits of the services in the sandbox to the Access to Justice initiative.
Thank you for that clarification.
I think, Randy, that's a threshold issue. What is our approach here? As I mentioned, I put this together thinking that we'll take a risk-based approach, not a benefits analysis approach, because of the way that I read the introductory paragraph on the second page of the memo for this meeting. It talks about an assessment of the pros and cons of a sandbox. That's different from the pros and cons of what sandbox entrants are proposing as a way to foster experimentation in a manner that protects the public. So if the goal is protecting the public, that seems to me to counsel a risk-based approach and not require, I mean, I think it's a critical issue here. If you have to engage in a balancing and benefit has to outweigh risk or at least equal risk, I think that's a very different kind of approach.
Can I ask a question? Have we moved away from looking at the risks that are inherent to certain areas of the law as opposed to others as a measure as well?
No, my answer would be that might, that would guide the kind of information that we collect. We may want to collect more and different information from sandbox entrants who are proposing to provide services in particular substantive areas of the law. That's the way I'd come at it.
Well, and Judge Chang, if I guess I could share the way I look at that is if somebody came to the sandbox, whether it's a Utah one or a future California one, proposing as a non-lawyer to handle felony criminal cases or something, I think we would all have a different reaction, to that in terms of the gravity of the issues and the required competency. And we'd have serious questions about whether that type of a service could ever be, meaningfully provided. So I guess I'm not sure if that's touching on your point, but I think it does have to do with the nature of the service that the provider is proposing to provide, where these harms may be perceived.
Okay, I think I was more thinking about immigration is what the one that always keeps coming into my mind, is because one, that is an area where you have a lot of people trying to provide services without a lot of background. And I can see that being an area where potential providers would like to develop a product. The potential harm in issues with immigration, they can be permanent and they can be fatal. And so I think the risk in that sense is a very, very different risk. And I just was wondering if is there any thought about whether there were just certain things that would be excluded just from the get-go, just because it's not appropriate in this setting.
I wouldn't advocate for closing entire areas of practice from eligibility for the sandbox. I'd be interested in knowing before doing that, for example, what the degree of lawyer involvement in the proposed entity is. And you could, for example, have an entity that was predominantly lawyers but involved fee sharing with non-lawyers to do immigration work. I wouldn't necessarily conclude that because it's immigration work, that shouldn't even qualify for entry into the process. I think
I guess if I could just add to that, I think that Judge Chang's comment and Randy's comments are kind of tied together, because the other concern here to me is that there is a clear and understandable disclosure, like taking immigration clients in particular, of what this service is and how it works and what it will and won't do for them. And so I think the disclosures are a way that you address the potential for harm, so that the person is adequately informed about what they're actually choosing to do. And the way that ties to what Randy said is, I guess the working premise is that a duly informed consumer will make an economic choice about what benefits them and what does not benefit them. And therefore, the benefit side of the equation is something that is answered by the market. And it's really the regulator's responsibility to deal with the risk side of that equation.
So should we go, should we move from what we've been discussing to what we have started discussing, which is the risk assessment and the matrix?
If I just add something to this discussion on immigration. Being an immigrant myself, which you can't tell because I'm coding right now, which means that I'm not expressing my accent. My biggest concern is with people who are going to, the potential risk of people who are non-native speakers who access this platform, assuming that they're going to have the resources that they need. But if there is someone that enters this platform with predatory natures and takes advantage of the non-native speakers, how easy is it for them to go through the appeal process and things like that? They cannot easily advocate for themselves. And I echo Judge Wendy's sentiments that she mentioned earlier, that there is a big concern and these things can be fatal. So thank you for letting me add that.
Mary, did you want to move on to the next point?
Well, I think, I mean, that Patricia's comments and Judge Wendy, I love that term, Judge Chang's comments, you know, add a dimension of thinking about a risk assessment, a sort of a risk matrix, you know, which is what we're trying to look at right now, you know, is how to make an assessment about, you know, sandbox participants. Utah uses this criterion of lawyer involvement, and you've suggested, Jim, that for you might be sufficient to address the kind of concerns that Judge Chang and Patricia have just raised. But maybe, you know, why don't we, if it works for you in terms of what we are in terms of your outline, to talk a little bit about, you know, is that degree of lawyer involvement, is that a sufficient criterion to define risk for us?
Yes, that would take us to outline item 3A on the second page of the outline.
Yes, and I don't mean to skip over, Jim, your second point, which is a big
Yeah.
topic.
That's okay.
Yeah.
Where the discussion has taken us, that's okay. So the Utah manual, if you had a chance to look at it, identifies 10 different service models. And the reporting requirements and the frequency of reporting vary depending on the service model. And the service models are categorized in general terms by degree of lawyer involvement. The more lawyer involvement, the assumption is the less risk, the less information is required to be reported, reporting is less frequent. Conversely, with less lawyer involvement, you have to provide more information and you have to provide it more frequently. But their differentiator is degree of lawyer involvement. They don't have anything that differentiates on the basis of substantive area of practice. Immigration, for example, relative to real estate matters. So this is a very fundamental concept. I think I see why Utah did things the way they did. You have to be able to manage this process efficiently. One size fits all won't work, but neither will separate data collection and reporting requirements for every entity based on a case-by-case determination of what would look good. So they chose that one criterion. What do we think of that? Now as I said, in explaining how the lawyer involvement might deal with the immigration situation, that is one way of mitigating risk. Yes, the stakes in immigration cases are still high, although it could depend on all immigration cases are not the same. They're not necessarily all going to be opposing the threat of deportation. But how comfortable are people with the idea of using lawyer involvement as the general differentiator? Do you think there should be different differentiators? And if so, what are they? I guess I'd ask John maybe to give us a little on the ground information about how this is playing out in Utah. Based on your experience to date, what is your sense of how degree of lawyer involvement works as a proxy for assessing, for assigning categories of risk?
Well, one thing to know is we've really seen almost no providers at the high end of the scale that are non-lawyer providers or software-only providers without lawyer involvement. So I'm not sure what to make of that. We did just see, some of you may know Stacy Butler from the University of Arizona, who's a professor doing work around debt collection and debt procedures. And she just got approval to have some non-lawyers around, I can't remember which social agency it is. It might be the Catholic Charities, but one of the local nonprofits got approval to have non-lawyers negotiate medical debt for people without any lawyer involvement. And that's an example, the only example we have so far of something on the high side. But to the question you asked, Jim, about, is the proxy working as an indicator of risk? I don't know that we've seen enough data to answer that. I think we're just still, I would certainly say our court, in considering applications, certainly continues to take comfort from the involvement of lawyers in the process. And we've had some pretty beefy discussions around situations where non-lawyers are going to provide services with lawyer oversight or lawyer involvement. They've wanted to have a real clear idea about the level of lawyer oversight and involvement. You know, if all you're going to do is train non-lawyers to do a particular task and then never check on them and never do anything other than train them in the first place, that does seem qualitatively different to our court than if there is spot checks by the lawyer or some kind of other structure that makes it clear that the lawyer is still, you know, directly engaged in the ongoing work. So I guess I don't have a lot of data yet, but I think we still like the logical premise that the more lawyer involvement there is, the less likely risk there is to consumers.
I'm curious, I may pose the question here, will this approach deter innovation? If the categorization signals that the general approach is lawyers good, non-lawyers bad, I'm exaggerating, that may tell the market, don't bother coming here for a non-lawyer proposal. It could keep people who have an entrepreneurial approach and an innovative approach that might be beneficial to the public away. Have you had any nibbles from non-lawyer entities inquiring about the process who then disappeared and didn't follow up?
You know, not really, not that would somehow relate to the idea of needing to have lawyers involved. I mean, I think even our non-lawyer providers seem to have a lot of openness to having lawyers involved because they, whatever reason, maybe it feels like it gives them credibility or it gives them accountability or just they need the skill set. It doesn't seem like there's many folks that want to go it alone and provide legal services without some involvement from the lawyers.
One other point on this, John, I guess I'm just see if this fits with your kind of experience, but we also don't want to be second guessing the regulatory system surrounding lawyers. And it seems like if we didn't use the lawyer standard, we would almost be saying, you know, that we're trying to sort of have a different and presumably better standard. So as an entity that's initially experimental, it seems like I'm not sure what other one we would use without, you know, having just a totally different, you know, if we're not using the baseline as kind of the existing regulatory structure for lawyers, I feel like we're doing something a little different than our task. But I don't know, I thought I'd throw that out and see if you disagree.
I don't know if I have a strong feeling about that aspect of it. It's just, I mean, the other piece going on with all of these proposals is they're a discrete proposal. I mean, we have the multidisciplinary model where there's a range of services maybe, but in these instances where, as I mentioned, the medical debt collection piece, it's a discrete area of practice. And maybe that's partly what gives us comfort with the potential risk is that we know, you know, you're not talking about non-lawyers doing some wide range of things that you don't have any idea what it will be. You're able to assess they're doing this particular task. And Eric, I guess that maybe that ties to the point of finding places where you can have the one-to-many model and really truly commoditize. It's going to be around, you know, that kind of a discrete, definable task than more so than everything a law firm might do for you.
I don't know if this is reassuring, but I mean, it's similar, just as you're saying that, to what's been going on in medicine, where you have, you know, physician's assistants and licensed practical nurses that have very discrete areas of practice that with differing degrees of supervision that they can undertake.
Well, Eric, I like your explanation of the Utah model as fitting with the experimental purpose of this. We have to start somewhere. And isn't this a logical place to start in light of the system that we already have?
If I can just add, I kind of had a different thought, Eric, in that maybe this could also be a way to test different ways to regulate lawyers. You know, I'm not sure our existing models, no offense taken to the members of the bar staff here, but I don't know if our existing model is ideal either. And I wonder if having more of a risk-based approach would be better for regulating individual lawyers, just as something to think about. So one thought I had, and I don't know like how this could actually work out, but if we're talking about threshold of risk, and to address Judge Chang's point, sorry for my coworkers' comments, is, you know, what about level of risk? I mean, there's a different level of risk from medical debt. It is terrible. I mean, it can be very bad, but versus being deported to a country where you might be killed. I mean, you know, there's very different aspects at stake, and couldn't that, I don't know how that would work with your matrix, John, but it occurs to me that maybe there is some room for looking at the actual risk of the the outcome.
I mean, to Bridget's point, and I think it's absolutely right. If you think about immigration cases, I'm not sure what the follow-up is. You know, I mean, if someone is deported, you know, it's unlikely they're going to be able to file a claim, you know, or file something with the bar that they didn't receive adequate legal representation. I mean, I'm guessing there's very little ex post regulation of those cases going on, and a situation where, you know, the company had to report, you know, hey, we were, you know, we had about a 2% success rate on keeping people in the country in these cases. You would have more information than say the bar would. So I take your point, right? You know, that this, because this has the possibility of following up in a way that a system that requires someone make a complaint about an attorney, this system could have much better outcomes than something like immigration cases, because you'd at least know what was happening with what the service the firm was providing.
And on behalf of the state bar, I would say that we take no offense to the suggestion at all. We're exploring risk-based regulation for attorneys in a variety of areas. And, you know, if we were putting the model together today, you know, would it be the complaint-driven process we have? Maybe, maybe not. I don't know the answer to that question, but the goal certainly is, I would think, is not necessarily to replicate the complaint-based model that we've got for the attorney system. So we're excited to explore new and different opportunities and looking at this from a risk-based approach.
This is Mary. I can't tell if I have my hand up or not, so I'm just going to jump in. Let me just say, though, that what we're talking about here, just to make sure I understand it, in terms of the risk assessment matrix, this is to help us devise a way of evaluating the risk posed by different types of providers, which in turn could dictate the kinds of data that the sandbox would collect from those providers, and may have other reporting implications, other implications. The question of standards of conduct and discipline and those kinds of things, which is related to risk, obviously, but that's a separate topic, at least as I'm framing it, and that's what is addressed in our outline for item number 6, which it doesn't look like we're really going to get to today. But just to say that I think there are potentially different, those are potentially different issues. No, and maybe not. If not, please help me, better understand it all.
No, sorry, I was just responding to Eric's comment that I don't know if we should. I just don't want to be deterred by the fact that we already have an existing structure for attorney discipline, and that we don't want to wade into that. That's all. I wasn't trying to suggest that we get into that.
Okay.
So I see hands both from Wendy and Justice Tucker.
Wendy first.
She logged off.
Oh, okay. So
I forgot to lower it. Sorry.
Yeah, took her hand
When I first saw this table of risks, I really liked it. But the more I live with it, and by this table, I'm referring to the one on page 7 that's referenced here in the outline. But the more that I lived with it, the less certain I was that it was helpful, partly because of the reason that Judge Chang and Ms. Skatira make about the stakes for certain kinds of things. Partly because if you look, for example, at the lawyer employed or managed by a non-lawyer, risk low, well, that's maybe true in or fee sharing with a non-lawyer. That's maybe true in some circumstances. If you're thinking, for example, about the lawyer who's now going to bring his paralegal in as a junior partner in fee sharing, on a fee sharing basis, certainly that would seem like a low risk proposition. But if you're talking about Walmart buying out personal injury practices by the boatload, that I don't know that we would want to say that's a low risk proposition. It's a radical transformation with potential destabilizing and conflicts issues for our entire sector of the personal injury bar. So maybe rather than making a table that categorizes based on lawyer involvement, we try to track more from what are the kinds of risks associated with this kind of model. And it may be related in part to lawyer involvement, but it may be related to scale of the enterprise, or it may be related to stakes of the legal services provided, and that we, in that sense, not have a single linear ranking of risk, but say we want to look at all these different kinds of factors, or at least these 3 different kinds of factors, in deciding what's an appropriate regulatory scheme for the individual applicant.
Justice Tucker, are you suggesting a more multi-part matrix?
Well, I hate to make things more complicated. I don't want to say, let's set up 3-dimensional chess, but I have just identified 3 different vectors. So I'm not quite sure where this idea leads. It may lead to just dispensing with the table that labels any category low risk based on lawyer involvement, for example, but simply says in general, and looking strictly at the question of lawyer involvement, the more lawyer involvement, the less risk. However, we would also want to look at the stakes of the services being provided and the scope of the intervention or the application being proposed. And then based on each of those kinds of criteria, we would then, that is to say the SANDBOX entity evaluating the application, would then put together a menu of data requirements and other risk-based regulatory tools to assess the amount of risk that we found based on all 3 of these vectors.
This is Mary. We're getting very close to our end point, and I think those are all really good points. I do just want to make one point, which is one of the concerns that you just raised, Justice Tucker, as a risk. For example, the potential disruption to the legal services industry by Walmart's coming in and buying up personal injury practices is certainly a phenomenon that would have potentially important effects that we would want to consider. I'm not sure those concerns really relate to the harms that we identified, particularly when lawyers would still be the ones providing the services. Lawyers are still held to all of the standards and rules and professional requirements that they are. it's a concern, it might be a larger policy concern that's somewhat different than the kind of regulation of the lawyers in the sandbox. But I'm not sure, in any event.
Not disagreeing.
Yes, and that the two actual vectors that you identified are not necessarily ones that go exclusively to that kind of analysis anyway. So, but it's 2:57. This has been a really great discussion. I don't mean to cut us off. We still have a few more minutes, but just pointing out that the time, we never got to the outline for number 6. So we'll figure out what to do there. You know, I guess, Jim, from your perspective of trying to move this outline along for number 5, do you have any last issues that you'd like to try to discuss in 2 minutes or less?
The answer is no, not today. I'd suggest that the next time we take up with the issue we've been discussing, what are the categories? That just seems to me to be a foundational issue for organizing our work. As I said, I don't think we can do this one size fits all. I don't think we can do it case by case. We have to come up with some organizing principles that allow us to identify what we're going to ask for from whom.
I'd just like to thank Jim and I think everybody for a really thorough conversation, a good start on this, and, you know, thoughtful comments all around. It seems like it really helps the process if we can continue to have these kind of conversations.
Totally agree.
I'm sorry we missed out on Andrew's comment. I bet it was about soccer.
Yeah, you know me.
All right, then, everybody, why don't we adjourn and we will continue the work in the off season.
Nice.
It was the best I could do, honestly.
That's great.
Pretty good.
All right.
Take care.
Thanks, everyone.
Bye, everyone.